This is a lecture from Open Tuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
This chapter looks at some legal obligations, particularly with reference to information processing, health and safety at work, dismissal, your safety of your job, if you like, security of your job, and consumer protection. First of all, however, we'll just look at the sources of law. And again, this obviously varies from country to country. If we're dealing with the UK or countries in Europe, then at the moment there is European Community Law. Obviously, when this recording is being made, the UK appears to be leaving the European Union. But for countries which remain there, the European Union, European Community, can pass laws, either laws which are directly become laws in the member countries, and those are known as regulations, or directives, which is really a directive to the local parliament to pass a law which is broadly in line with the wishes of the European Union. All countries then have their own domestic parliament or domestic mechanisms for passing laws. This is normally known as legislation or statute. These are written out so that people can read and understand and interpret what their obligations under the law might be. Now, many countries have a system of case law. In the UK, for example, we have got very historical cases where judgments were made maybe years and years ago, and depending on the seniority of the court which made certain judgments, then inferior courts have to follow. That's known as precedent. So these laws, I think, are gradually being overtaken by legislation and statute because more detail, if you like, and maybe exceptions are added through the statutory mechanism. Anyway, starting with information technology or data processing. Again, this is EU stuff, or British stuff, but by and large, many countries have got something very similar relating to the protection of their citizens from information being held by third parties. The European Union General Data Protection Regulations came in 2018, and this affects the holding and processing of information within the EU. And indeed, it also can affect the holding of information of European Union citizens if the information is held elsewhere. In the UK, this EU legislation has been brought in under the Data Protection Act 2018. And there's nothing terribly surprising in these 6 principles, as they're known. The data should be processed fairly and lawfully. And one of the aspects of that is that the data cannot be being held and processed lawfully if it has been obtained in an illegal manner, maybe by eavesdropping, maybe by bugging, if you like, maybe by hacking. The information has to be held for specific purposes, one or more specified and lawful purposes. In other words, companies aren't simply allowed to accumulate information in case it sometimes becomes useful. It has to be adequate, relevant, and not excessive. So, holding information for one purpose does not give you the opening, if you like, to hold it for all sort of other purposes, just in case it becomes useful. It has to be accurate and, where necessary, kept up to date. It must be deleted whenever it's not needed anymore. and it must be held and processed securely. And of course, there have been a number of recent breaches on the security of websites where a lot of confidential data has been leaked, credit card information and so on. And some firms come in for very large fines from the data protection agencies because it said you haven't been holding this data sufficiently securely. Next, we have within this the rights of the data subject. Now, a data subject is someone like you or me. It's the person about whom the data is held. And this Data Protection Act here, it refers to what's sometimes called personal data. It has to be about a living person. The information, the regulations, the law does not apply to, say, holding information on companies. It is personal information. So we are the data subjects, and we have the right to be informed that data is being held about us. We have the right to see it, to access it. If it's wrong, then we have a right to insist that it is corrected, that it is rectified. We can ask people to restrict processing, don't use it anymore for certain purposes. Rights to portability. So if someone has collected legally a lot of information about us, we are entitled to receive that information in a way that might be convenient for us, that maybe we're going to use it in some other purposes. We have the right to object to the information being processed in a particular way, with a right as well, of course, number 4, to restrict processing. So we can say you're holding the data, but do not process it any more. We have the right to object to them holding data and the way they're processing it. And we also have certain rights related to the operation of automatic decision making. So if you are applying for a job and you put in your qualifications and so on, sometimes these applications are initially filtered automatically, and there are rights which ensure, if you like, that we're not unduly prejudiced by this perhaps incorrect automatic decision making made by information processing systems. There are special considerations if data is going to be transferred outside the European Economic Area. In other words, maybe to a jurisdiction which is going to be careless with the data, or which hasn't got the same sort of legal penalties and legal regulations that exist in the European Economic Area. It should also be said that although we have all of this apparent right to see the data held about us and so on, there are special rules and regulations dealing with police forces and security agents. We can't go to MI5, MI6 and ask them to show us the data that they're holding on us, fairly obviously. The risks to data, because if data is being held, a lot of data can be held in one place. It can be subject to considerable risks, and once, if you like, a database is broken into, huge amounts of data can be siphoned out very quickly or destroyed very quickly. And so it's very important that the data is held securely and in ways which minimizes the risk. And the types of risks which we have are human error, simply somebody typing in the wrong figure. How I can remember, it was to do, I think, with a mortgage on a flat, and I was trying to we paid back the loan or something, or we'd sold the flat, I can't remember what it was. We were trying to get the mortgage lifted, and I had to supply my date of birth. I supplied my date of birth, and I was told that was wrong. And all I could say, well, that's always been my date of birth for the last 30, 40 years, whatever it was. But obviously there'd been a human error in typing in initially my date of birth. Technical malfunction or error. There have been a number of situations in the UK where banks, when updating their processing system for check clearance and payments and working ATM machines and so on, has gone wrong. It wasn't sufficiently tested, and people were unable to access cash, unable to see their bank account for perhaps 2 weeks. So that is just a technical malfunction or error. I can put with that malicious damage. This can be through viruses. Somebody gets access to the machine, it changes information, it deletes information, it scrambles information, whatever's going on. It can, of course, also be malicious damage to hardware. Catastrophic events, like a fire, like a flood, like a terrorist incident, where the whole IT system might be destroyed. And we have to safeguard against this. We have to make sure that the IT hardware is somewhere safe. There's fire detection, there's flood defenses, and so on. We have to make sure that we take regular backups of the data, so that if the machine is destroyed, we can go back. And where an organization is kind of using IT all the time, like maybe it's taking orders over the internet, like an airline, then to guard against catastrophic events, normally what they have is their main computer, and then in a completely different town, even a different country, they have a kind of mirroring computer, and these work in parallel, duplicating results. So if one is destroyed, processing can more or less continue unhindered. Industrial espionage and sabotage, again, a lot in the news about sabotage, a lot in the news about industrial espionage, where people hack into the system and they suck out plans and plans for machinery, your strategic plan and so on, and can make great use of that. And finally, there is dishonesty, basically fraud. People changing data, stealing data to enrich themselves. So all of these risks have to be guarded against in some way or another. For example, the use of passwords, the use of physical logons like fingerprints, like retina scans, antivirus software, anti-hacking software to prevent unauthorized access from outside the system, parallel systems ready to switch on if our machine goes wrong. All really, really important for many businesses in the current climate. Health and safety. You will understand that in certain businesses, particularly manufacturing businesses, agriculture, the construction industry, there are a large number of possibilities whereby employees can be injured or killed. And laws, certainly in the UK, tend to be very, very strict about health and safety. If they are breached, and if someone is injured and it's found that the employer wasn't acting properly, then there are very large financial penalties indeed. So, without going through everything here, work practices must be safe, the work environment has to be safe and healthy and so on. We have to maintain the plant and machinery so that it's safe. We must train people, we must communicate to people the responsibility they have, and we have to carry out risk assessments. In other words, we think, what could possibly go wrong, how could people possibly get hurt. And then what we can do is we can then draw that back a little bit and say, yes, well, they could get hurt, but frankly, the likelihood of them getting seriously damaged is relatively small. Employers' duties, they have to share information with others. We have to, for example, employ competent safety and health inspectors and so on. Have to introduce controls to reduce risk. We have to involve employee representatives, which would normally be trade unions, on committees so that people can together discuss where they think the risks are and how best to overcome those. However, employees also have certain duties. For example, they have to take reasonable care of themselves and others. If a couple of employees were, shall we say, kind of playing around, throwing something to one another, throwing a knife, one to the other, then that's liable to be regarded as a very serious breach, which could lead to discipline of the employee. You can't really expect the employer, to be constantly watching that adults, if you like, are acting sensibly and not throwing knives and, the like to one another in a very dangerous manner. Employees must allow the employer to carry out safety tests and repairs and so on. You mustn't interfere with the machinery. You mustn't take off guards and so on. It may be convenient if you take off some sort of guardrail or something. Maybe you can reach something more easily. But of course, it may mean that you get your fingers trapped more easily as well. If the employee notices anything which they think is dangerous, slippery stairs, carpet tiles coming up that you could trip on, then it is their responsibility and duty to inform the employer. The employer must then have a responsibility, of course, to do something about it. And equipment should all be used properly. Employment protection. It's very, it's pretty important that people feel secure in their jobs. It's not a great situation if arbitrarily you can lose your job. And we're looking here at the termination of employment. And it can be through retirement. And obviously there's no trouble with that. That's a voluntary type of act. So is resignation. Where the trouble really comes is with dismissal. It can be termination, which is saying you are sacked. It can be non-renewal of a fixed term contract. So if you're employed for 3 years and at the end of that you do not have a contract renewed, then that is dismissal. And then there's something called constructive dismissal, which is really your employer acting in such an outrageous way that you are entitled to deduce or assume that you have been effectively dismissed. Most of the protection from unfair dismissal comes in. So in the UK, you have to be employed for about a year before you get some sort of a security. Fair dismissal. Fair dismissal is redundancy. So the job disappears, you close down a branch in a particular town. There were 10 people employed there. We don't, their jobs don't exist anymore. That is fair dismissal. There will be compensation for it, but it's fair dismissal. A legal impediment. If someone is employed as a van driver and for some reason loses their driving license, they're obviously not allowed to drive a van, then that is grounds for dismissing them. Non-capability. You're simply no good at your job. You've been given a chance, you've been given training, you've been given time to improve, and still you can't hack it. The employer is not obliged to carry passengers, and after suitable support and warnings and so on, you can be dismissed. Misconduct. It could be minor, it could be major. There is such a thing called gross misconduct, where you can be immediately dismissed. And then there can be more minor forms of misconduct where you might be given a warning, maybe a verbal warning, then a written warning. You do it again as a final written warning. You do it another time, you're out because you're showing no signs of learning or improvement. And there may then be a bit of a catch-all, some other substantial reason, which is going to be pretty rare. Unfair dismissal. Unfair selection for redundancy, that you happen to make redundant, let's say, all the female workers and keep employed all the male workers. the normal way to go for redundancy is something like first in, first out. You can't be dismissed for being a member of a trade union. You can't be dismissed by reason of becoming pregnant. You cannot be dismissed simply because you insist on the documentation to which you're entitled. And you cannot be dismissed if you insist on carrying out certain actions which are needed for health and safety. If you are dismissed, and you then would typically go to an employment tribunal, which is a form of informal court, then if the employment tribunal finds you have been unfairly dismissed, there are 3 remedies. First of all, you can be reinstated. In other words, you get precisely your old job back. That's fairly rare, because by the time this comes round to the employment tribunal, probably someone else has replaced you in your job, and your job is simply not available again. Secondly, there is re-engagement. You are re-employed in a job comparable to the old one in terms of responsibility and salary. However, you will realise if you've gone through unfair dismissal, if you've taken your old employer to court, then relationships aren't that great. And by far the commonest remedy is a financial remedy. There'll be redundancy pay, there may be an award for breach of contract, there may be a punitive award, which is really where the employer is punished for what they did by giving a lot of extra money to the employee. Finally, consumer protection. Contracts, even before we get on to looking at the statute, but under the old common law, case law of contracts, they have implied terms and conditions and also expressed terms and conditions. So if I say I'm going to sell you this pen, it's an implied term and condition that I own the pen, and therefore I can legally sell it. So it doesn't have to say in the contract that I own the pen. It's an implied condition. It's an implied condition that the item is probably fit for purpose and so on. And then there can be express terms and conditions that you will do this by a certain time, or you will deliver the goods by a certain date. They can be written into the contract. If any of these contractual terms and conditions are breached, the 2 remedies are first of all damages, which is basically a form of compensation, and if possible there is the remedy of rescission, and rescission means trying to put both parties back to the state they were in. So if I sell you the pen, and let's say you give me $2 for the pen, and then you find it doesn't work, rescission would mean I give you the pen back and you give me the $2 back. And so we will put back where we are. If, however, I sell you the pen and then you sell it on, and that other person finds it doesn't work or comes after the first buyer, then it's going to be very difficult to unravel this chain of events. Rescission might not be easily possible, and it may simply come down to damages. As well as the old contract law, the case law, many countries then have additional consumer protection legislation. For example, stating that the goods must be of satisfactory quality, that they are fit for purpose, that they are as described. And this overrides any kind of guarantees. So the guarantee might say this is guaranteed for a year, but if the type of object which it is, people look at it and say, well, that should last for 3 years, and it stopped working after 15 months, then the consumer protection legislation would overrule that guarantee figure, and you could get your money back, you could have a replacement item, or you have your item repaired, all free of charge. And also there can be product safety legislation. So if you're, for example, selling toys to children, then you have to be careful about sharp objects or damaging paint or something of that type. If you're selling electrical goods to adults, then you have to make sure that it is electrically safe. It's not going to go on fire. It's not going to give electric shocks to people and the like. And as you would expect, if people breach the product safety legislation and if damage is done to a customer, then the penalties can be very steep indeed.